Imagine waking up one morning to discover that nearly $2 billion, money you'd invested, trusted to experts, believed was safe, had simply vanished. No warning, no explanation, just gone. This isn't a hypothetical. This is happening right now in 2026, and the stories behind these disappearances reveal a chilling truth about fraud in America. It's bigger, bolder, and more brazen than ever before. Welcome back to the Verdict Room. I'm your host, and today we're diving into the biggest fraud cases of 2026, cases involving billions of dollars, shattered lives, and the legal battles that are exposing some of the most sophisticated criminals operating in plain sight. Let's start with a crisis that's been brewing beneath the surface of one of America's most glamorous industries: real estate. In 2026, investigative journalists and financial regulators made a shocking discovery. Real estate, the industry built on trust, on promises of investment returns, on the assurance that your money is secure, has become infested with Ponzi schemes. Not one, not two, dozens, hundreds. The sheer scale is staggering. According to reporting from The Real Deal in early 2026, real estate has a Ponzi problem. And it's not small. Developers, investment firms, and so-called trusted advisors have been orchestrating elaborate schemes where early investors receive returns paid directly from the funds of newer investors. It's the classic Ponzi structure, but dressed up in the language of real estate development, luxury properties, and guaranteed returns. Here's what makes these schemes so insidious. They prey on people's desire for wealth. They promise returns of 7, 10, even 15% annually. Numbers that sound too good to be true, because they are. But desperate investors, retirees looking to protect their nest eggs, families trying to build generational wealth, they buy in. They invest their life savings, and for a time the scheme works. Money flows in. Some investors receive their returns. The scheme looks legitimate. But underneath, there's nothing real. No actual development. No genuine properties generating income. Just a house of cards that eventually collapses, leaving devastation in its wake. In 2026, as these schemes unraveled, authorities began digging into the mechanics. Financial forensics teams, specialists who trace money through digital and paper trails, discovered that billions had been diverted. Construction never started. Properties were sold multiple times to multiple investors. Appraisals were fabricated, and the architects of these schemes were living lavishly off stolen funds. But here's where one case stands out with particular force: the Laguna Beach arbitration decision that sent shockwaves through the legal community. In what may be one of the largest fraud arbitration awards in American history, a Laguna Beach property owner was awarded $1.34 billion, $1.34 billion, in a fraud case following arbitration proceedings. Let's break down what happened. A property owner in Laguna Beach, California, had invested substantially in what he believed were legitimate real estate development opportunities. The promises were specific: beachfront development, luxury residential properties, a portfolio that would appreciate over time and generate significant returns. Instead, what he discovered was a carefully constructed fraud. The developer had misrepresented the projects, funds had been misappropriated, documents had been falsified. And by the time the truth emerged, the damage was catastrophic. Here's what makes arbitration different from a court trial. It's faster, more private, and typically conducted by an arbitrator or panel of arbitrators rather than a jury. The property owner pursued arbitration, presenting evidence of the fraud. Financial records showing where money went, expert testimony about the misrepresentation, documentation proving that the development projects never occurred as promised. The arbitrators ruled decisively: the property owner had been defrauded. The award, $1.34 billion. In a single arbitration decision. Let that sink in. One case, one property owner, $1.34 billion in damages. Now here's the legal reality that people often don't understand. Getting a judgment, even a massive one, is only the first step. Collecting it is another battle entirely. The defendants in these fraud cases often claim they can't pay, or they hide assets, or they file for bankruptcy protection. The legal system then enters a phase called collection proceedings, where creditors, in this case the defrauded investors, attempt to seize assets, garnish accounts, or recover any remaining funds. It's a process that can take years. But real estate fraud isn't the only industry being ravaged by massive criminal schemes in 2026. The healthcare sector has become a minefield of fraud, but with a twist. Some of the fraud isn't criminal, it's civil, and it's costing hospitals, insurance companies, and patients billions. Consider the case that emerged from Cook County, Illinois. A woman underwent a hysterectomy, the surgical removal of the uterus, at a major medical facility. It was supposed to be a routine procedure. Instead, she suffered severe complications. The surgery, she and her legal team would later argue, was unnecessary. The medical justification for removing her uterus never materialized. She was left with permanent injuries, chronic pain, and a life fundamentally altered by a procedure that should never have happened. Her attorneys at Clifford Law Offices pursued a medical malpractice claim. Medical malpractice is a specific type of negligence claim in the law. It requires proving several elements: that a doctor-patient relationship existed, that the doctor breached the standard of care, meaning they acted in a way that a reasonable, competent physician would not have, that this breach caused injury, and that the injury resulted in damages. In this case, the evidence was compelling. Expert witnesses testified about surgical standards. They explained why the hysterectomy was not medically justified. They detailed the complications that should never have occurred. And they quantified the damages, the pain, the suffering, the lost quality of life, the medical expenses, the lost wages. Following a 2-week trial in Cook County, the jury returned a verdict that sent a message: $7.25 million. $7.25 million for a single surgical error. It became a record verdict for hysterectomy malpractice in Cook County. What's crucial to understand here is why these verdicts matter legally. When a jury awards massive damages in a medical malpractice case, it creates precedent, not in the formal legal sense, but in the practical sense. Insurance companies take notice, hospitals review their procedures, doctors become more cautious. The message becomes clear: unnecessary procedures carry enormous legal and financial risk. But we need to zoom out and look at the bigger picture of fraud in 2026, because healthcare fraud extends far beyond individual malpractice cases. It includes pharmaceutical fraud, medical device fraud, billing fraud, and insurance fraud. In 2026, the SEC, the Securities and Exchange Commission, has been aggressively prosecuting white-collar crime. The Department of Justice has doubled down on healthcare fraud cases. And forensic accountants have become the new detectives of the criminal underworld. These investigators use sophisticated tools, digital forensics to recover deleted emails and messages, data analytics to spot patterns of fraud, financial tracing to follow money through shell companies and offshore accounts. When a corporation or individual commits fraud at scale, they typically leave traces, digital breadcrumbs that can lead investigators back to the crime. Consider how modern fraud is actually detected and prosecuted. It rarely happens because a victim simply reports it. Instead, it often emerges through whistleblowers, insiders who see the scheme and decide to expose it. The Dodd-Frank Act, passed after the 2008 financial crisis, created the SEC's whistleblower program. It incentivizes insiders to come forward by offering financial rewards and legal protections. In 2026, whistleblowers are responsible for exposing billions in fraud. When a case reaches trial, the prosecution must prove fraud beyond a reasonable doubt. That's a high standard, higher than the preponderance of the evidence standard used in civil cases. The defendant must have intentionally or knowingly misrepresented material facts, with the intent to induce reliance, and the victim must have relied on the misrepresentation and suffered damages as a result. In white-collar fraud cases, the challenge is that perpetrators are often intelligent, sophisticated, and well represented. They use complex corporate structures to hide money. They employ accountants and lawyers to obscure trails. They create plausible explanations for their conduct. Proving intent, proving that they knowingly committed fraud rather than made honest mistakes, can be extraordinarily difficult. But when prosecutors succeed, the consequences are severe. Prison sentences range from 5 to 20+ years, depending on the scale of the fraud. Fines can reach hundreds of millions of dollars. Defendants lose their professional licenses. They're barred from serving as corporate officers. Their reputations are destroyed. And in many cases, restitution orders require them to pay back defrauded victims, though collecting from imprisoned defendants is often impossible. Here's what 2026 reveals about fraud in America. It's not disappearing. Despite increased enforcement, despite technological advances that make detection easier, fraud persists. Why? Because the financial incentives are enormous. A developer who steals $100 million faces serious consequences if caught. But if they succeed, they accumulate generational wealth. An executive who commits fraud might spend 5 years in prison but retire with $50 million. From a cold risk-benefit analysis, for some people, the math still favors crime. This is where regulatory reform becomes crucial. In 2026, there are ongoing debates about whether penalties are steep enough, whether enforcement is adequately funded, whether sentences are sufficient. Some argue that white-collar criminals receive preferential treatment compared to those convicted of street crimes. A person convicted of drug distribution might receive 10 to 20 years in prison. A person convicted of fraud involving millions might receive 5 years. Is that justice? It depends on who you ask. From a defense perspective, these cases often hinge on proving that the defendant acted honestly, that they made mistakes, certainly, but didn't intentionally deceive anyone. Defense attorneys emphasize the complexity of business, the ambiguity of financial reporting, the possibility of honest disagreement about valuations and projections. They humanize their clients, highlighting charitable work, family, community ties. They argue that incarceration serves no purpose when the defendant can make restitution. From the prosecution's perspective, fraud is fundamentally about betrayal. It's about someone in a position of trust, a financial advisor, a developer, a doctor, a corporate executive, exploiting that trust for personal gain. It victimizes the vulnerable, retirees, families, people desperate to build wealth, patients trusting their healthcare providers. Prosecutors argue that severe penalties are justified because they're necessary to deter fraud and protect the public. What we've learned in 2026 is that fraud investigation has become a specialized field. The FBI maintains white-collar crime units. The SEC employs investigators who are part financial forensicist, part detective. State attorneys general have fraud divisions. And increasingly, private law firms maintain forensic teams that work on behalf of victims in civil cases. The cases we've examined today, the Laguna Beach arbitration, the Cook County hysterectomy verdict, the real estate Ponzi schemes infesting the industry, they're just the surface. Beneath lies a vast landscape of fraud, cryptocurrency schemes, online investment fraud, insurance fraud, mortgage fraud. In 2026, as financial systems become more complex and digital, fraud evolves accordingly. But here's the concluding thought that matters. These cases show us that the legal system, despite its flaws, eventually catches up. Investigators find evidence, prosecutors build cases, juries render verdicts, arbitrators award damages. Justice may be slow and it may be imperfect, but it does arrive. And when it does, it sends a powerful message. Fraud carries consequences. The victims in these cases, the investors who lost their life savings, the woman who underwent an unnecessary surgery, the families whose wealth was stolen, they may never fully recover. But the legal system's willingness to hold perpetrators accountable, to award massive damages, to impose serious prison sentences, provides some measure of justice and deterrence. So here's my question for you. As fraud becomes more sophisticated and prevalent, should penalties increase? Should white-collar crime be punished more severely? Should corporate executives face personal liability for their company's fraud? These are the questions legal reformers are grappling with in 2026. I want to hear from you. What's your verdict? Comment below with your thoughts on these cases and on how America should address the fraud epidemic. And if you're interested in the intersection of crime, justice, and law, subscribe to The Verdict Room. We break down the biggest trials, the most compelling legal cases, and the system that determines guilt and innocence. Thanks for watching, and I'll see you in the next case.